Thank you, everyone. Thank you for attending this webinar that will focus on the topic of marine geoengineering and more specifically the report that was prepared for the Center for Innovation and Governance, Center for International Governance Innovation. And I'm Wil Burns. I'm co-director of the Institute for Carbon Removal Law and Policy at American University and one of the authors of the piece. And joining me are Dr. Jeff McGee, who is an associate professor at the Institute for Marine and Antarctic Studies and the Faculty of Law at the University of Tasmania, as well as Dr. Kerryn Brent, the lead author for the study and a lecturer at the University of Adelaide School of Law. The way we'll proceed is all three of us will begin with brief interventions discussing various aspects of the study, and then we'll carve out the remaining time in our hour for questions. So with that, I'd like to provide a brief overview of the exigency that's driven this focus on climate geoengineering and to some degree marine geoengineering, as well as some of the marine geoengineering approaches that we've discussed and some of the potential risks and benefits and constraints that we outline in the study. So the impetus for discussing climate geoengineering, which is defined as deliberate, large-scale technological interventions to seek to address climate change, is the growing reality that the globe's feckless response to the issue of climate change has put us on course now for temperature increases of perhaps as much as 3.2 to 3.7 degrees Celsius by the end of the century, well above the salutary temperature targets that are set forth in Paris. The Intergovernmental Panel on Climate Change, in its fifth assessment report, in terms of its integrated assessment models, has indicated that there may be a critical role for one category of geoengineering, efforts to remove carbon from the atmosphere, denominated as carbon dioxide removal, at a very large scale of potentially 15 to 20 gigatons of carbon dioxide annually if we're to seek, in conjunction with aggressive efforts to decarbonize, meeting the objective of Paris. Moreover, many believe that the limited effectiveness of carbon dioxide removal responses, as well as the slowness of those responses to have an impact, may provide a compelling rationale for deployment of technologies in the other broad category of geoengineering, which is solar radiation management. Now, while much of the early discussion on the role of climate geoengineering focused on sulfur aerosol injection in the solar radiation management category, a technology that would inject sulfur dioxide into the stratosphere to seek to reduce the amount of incoming solar radiation that would be introduced into the troposphere, and afforestation and bioenergy and carbon capture and storage on the carbon dioxide removal side of the equation, there's growing recognition of the limits and the risks of these approaches. In the case of sulfur aerosol injection, many have pointed to potential risks associated with decreasing precipitation and potential impacts on the ozone layer. On the carbon dioxide removal side, many have pointed to the fact that bioenergy and carbon capture and storage might have huge implications in terms of diversion of land with associated increases in food prices, large biodiversity impacts, and large demands in terms of water. And as a consequence, there's been an increasing focus on potential other options to build a portfolio of geoengineering responses at levels that could reach the goal of perhaps 15 to 20 gigatons a year in sequestration, and solar radiation options that might have less negative impacts than sulfur aerosol injection. Among the options that have been discussed are some that are marine-based, and that's the focus of this study, which seeks to look at the potential risks and benefits of such approaches, as well as potential international governance mechanisms that would likely play a profound role given the likely impacts that many of these approaches would have in terms of the global commons and other nations' zones of jurisdiction. So among the options that we look at very briefly, on the solar radiation side, we look at marine cloud brightening, which is an approach that would disperse sea salt particles into maritime clouds in an effort to increase their nucleation. This in turn would increase their brightness, and it could reflect a percentage of incoming solar radiation back to space. Some studies have indicated that done at a large scale, it could be sufficient to offset the temperature impacts of a doubling of atmospheric concentrations of carbon dioxide, while other studies are less sanguine, indicating that perhaps it could reduce the amount of warming by about 35%. There are also, as we point out in the study, risks of this approach, including reduction of light and temperatures in oceans, which could potentially alter carbon uptake of oceans, changing seawater chemistry and phytoplankton production, as well as affecting other biogeochemical cycles and ocean ecology. We also point out the potential result of substantial declines in precipitation in some parts of the world, including South America. The study also on the solar radiation management side looks at the potential generation of microbubbles or foam, or the use of glass microspheres to be applied to ocean surfaces to try to substantially increase surface albedo and thus reduce the amount of incoming solar radiation that's introduced on surface. While some studies have concluded that these approaches could substantially reduce warming, as the study indicates, very little research has been done to date and very little funding is being provided at this point. Moreover, the study talks about potential risks, including exacerbating ocean acidification by increasing the efficiency of CO2 absorption in the oceans, as well as potential environmental impacts associated with artificial surfactants, as well as potential impact on oceanic species through temperature effects and the reduction of sunlight. On the carbon dioxide removal of the equation, we also look at several technologies. One is ocean iron fertilization, the idea of seeking to stimulate the production of phytoplankton through the introduction of substantial amounts of iron or ferrous sulfates, particularly in the Southern Ocean, trying to accelerate the uptake of CO2 by phytoplankton and ultimately storage in the deep parts of the oceans. As the study indicates, while some early studies had indicated that this might sequester as much as a quarter of all of the CO2 in the atmosphere, after 14 field experiments, many have pared down the potential and believe that it could play a minor role in terms of sequestration of carbon. The study also points out potential risks, including potential production of phytoplankton species that would not be palatable by zooplankton species, the potential to rob other ocean regions of nutrients, as well as threats associated with eutrophication and toxic algae blooms. A second approach that the study looks at is artificial upwelling and downwelling approaches. Artificial upwelling would seek to stimulate primary production in marine environments by taking up CO2 by drawing nutrient-rich water from beneath the photic zone to the surface. Some research says that this would have a modest potential in terms of CO2 sequestration, maybe less than 1 gigaton a year, and it could also pose ecosystem risks, including exacerbating ocean acidification and substantially restructuring ocean ecosystems by potentially favoring large phytoplankton. Ocean downwelling approaches are also looked at. These would seek to increase the rate of CO2 transfer to deep ocean regions by enhancing the transport of carbon-rich cold water into the deep ocean in a process known as the solubility pump. The study points out that there are very high costs associated with this approach, as well as fairly limited effectiveness in terms of sequestration. Finally, the study looks at two other approaches. One is ocean alkalinity enhancement. A number of researchers have proposed adding lime to the ocean in the form of calcium oxide or calcium hydroxide or calcium carbonates or silicate minerals such as olivine to increase total oceanic alkalinity. This in turn would result in chemical transformation of CO2 and long-term storage in the world's oceans of the CO2 in the form of bicarbonate and carbonate ions. Some studies have indicated this could result in modest drawdowns of CO2 from the atmosphere, perhaps 30 parts per million, while others see a much more dramatic potential impact of between 160 to 450 parts per million by 2100. The study also looks at the challenges in this context, including very high costs, high potentially energy needs in terms of production of materials, and potential ecosystem risks associated with increasing alkalinity for species that may not be able to adjust quickly, and as well as spontaneous precipitation of calcium hydroxide that could adversely affect coral reefs, as well as the potential release of other minerals such as cadmium, nickel, chromium, iron, and silicon into delicate ecosystems. And then finally, the study briefly looks at the potential role of blue carbon, which is increases of marine coastal macrophytes, including mangroves, salt marshes, seagrass, and seaweed assemblages. The study concludes that while there would be co-benefits of this approach, sequestration benefits are likely to be modest, and there are some potential ecological constraints to expanding the scope of blue carbon sources, especially in open ocean environments. This part of the study concludes that there is a need for substantial increases in research on some of these options, as well as needs for field experiments to begin our potential assessment of risks, benefits, and costs. And with that overview, I will now turn over the microphone to Jeff McGee.
Okay, thanks, Will. I'm just trying to share my screen here. Hope this will work. Everyone see that? Yep. Okay, good. Okay, look, Will's sort of set up the sort of technical aspects of some of these various ideas around marine geoengineering. As you can tell, there's a plethora of ideas out there in the scientific literatures and other literatures, which has been also well surveyed in the Gazamp report that Chris Vivian and Phil Boyd produced earlier last year as well. So there's a plethora of ideas around marine geoengineering. Rather than in our report seeking to address each of these ideas and to see how international law may or may not respond to each particular idea, what we sought to do in the report is to give a survey or an overview of the way the international law system is set up and its, I guess, strengths and weaknesses in terms of being able to respond to the marine geoengineering ideas as a class of potential things that are coming down the track. So the way we'll do this today, I'll just speak briefly about the I guess big picture aspects, the general landscape of international law, of existing rules that have been set up for other purposes, and how they may or may not intersect with these ideas on marine geoengineering. And then Kerryn will look more specifically at rules that have been created specifically for marine geoengineering, being the London Protocol provisions, and also some other things that are going on within the Law of the Sea Convention at the moment that may well be relevant. Look, in terms of the rules of international law broadly, what we see is, if we look at the system and the way it's set up, we've called it in the report a patchwork of various efforts at rule building over time that give us this system that has some agreements at a global level, which most countries are party to. So things like, if you look on the far left, that box there, treaties such as the Law of the Sea Convention, the 1982 Law of the Sea Convention, the United Nations Framework Convention on Climate Change from 1992, the Paris Agreement from 2015, that these sorts of global agreements apply across all areas of land, ocean, and atmosphere across the globe. They are, as I said, most countries are party to these agreements. It's only the odd exception, such as the US is not in the Law of the Sea Convention, but most countries are in these agreements. When we look at these agreements, that they do have provisions that are potentially relevant to marine geoengineering. Just as in domestic law, you have existing, say, environmental law that may be relevant for domestic geoengineering proposals, at an international law level, we have existing law that's been set up for other purposes that these marine geoengineering proposals may trigger. So, for instance, within the Law of the Sea Convention, we have provisions relating to marine scientific research in Part 8 of the Law of the Sea Convention. In Part 7 of the Law of the Sea Convention, we have provisions such as Article 192, which provide an obligation on states to protect and preserve the marine environment, and in Article 194, obligations to prevent, reduce and control pollution. So these type of broad obligations, as I said, apply to most countries and are potentially relevant to marine geoengineering proposals. But we'll speak a little further about that in a minute. The second type of laws, international laws that may be relevant, are in the middle box, and what we've called those in the report is sectoral regimes. These are smaller agreements, smaller numbers of parties, and they tend to be directed towards a particular issue or particular geographical area. So, for instance, you'll see in there, in that box, there's an image there for the Antarctic Treaty System, which applies to the southern part of the planet. The various fisheries agreements, like the SPREFMO agreement in the Southern Pacific region, regulates fisheries. OSPAR Commission in the Atlantic. So these sorts of lower scale, lower membership, more directed agreements that have often been set up for other, or all of them actually been set up for other purposes than marine geoengineering, but their rules may be triggered by some of these marine geoengineering proposals. So the third part of this patchwork of international law is what we term the principles of customary international law. This is the box on the far right. Now, these are rules which all countries are essentially bound to. They're unwritten rules. They're rules which countries are bound to as a result of accepting practices of states over the past in terms of understandings of rules and their legality. And there's some particular rules known as the rule against transboundary harm, or what's referred to as the no harm rule, which could well be relevant here for some types of marine geoengineering, particularly, say, ocean iron fertilisation, ocean alkalisation, marine cloud brightening. So types of marine geoengineering techniques at a large scale that could cross national boundaries or move from national boundaries into global high seas areas. There's particular rules there that seek to prevent harm or provide obligations on states to do certain things, such as environmental assessments and giving notice to other states when they're going to carry out particular activities that are likely to produce harm. So, as I said, this is a kind of patchwork of rules that are in existence that may be triggered by some of these marine geoengineering proposals. But the report identifies three significant limitations to this patchwork in terms of its ability to properly manage and regulate marine geoengineering activities. The first limitation I've touched upon, and that is geographical coverage. Many of the sectoral agreements in that middle box that I just had up, as I said, are very much directed around a particular issue or particular location of the world. So if we, for instance, look at the Antarctic Treaty, it has some really advanced and highly developed rules in the Madrid Protocol on Environmental Protection around environmental assessment. Those rules could be triggered by some of marine geoengineering activities if they're occurring in the Antarctic Treaty Area, but of course that Antarctic Treaty Area is only below 60 degrees south latitude. So, a very advanced set of rules that may well be helpful and triggered in, say, ocean iron fertilisation activities in the Southern Ocean, but limited to a particular geographic space. The second limitation, which we identify in the report of this patchwork of rules, is that it is limited in essence by state consent. That is the consent of the particular countries to each of these particular agreements that we've looked at in the report. The international law system is essentially a voluntary system in the sense that states need to consent to rules before they're bound to them, all except that customary international law that I spoke about. So, but more broadly, any agreements we're talking about, states have to consent to being a part of that treaty and being bound to those rules. If we look at the patterns of consent across these various agreements in the patchwork, what we see is the global framework agreements that I spoke about, like the UNFCCC and the UNCLOS agreement, have quite good coverage. Up in the sometimes approaching 200 countries are in those agreements. However, as we move across to the sectoral agreements, including the London Convention, London Protocol, which Kerryn will speak about further in a minute, what we see there is the actual coverage of key agreements drops off significantly. So, for instance, if we look on the far right, you'll see the ESPO Convention. Again, that's a very advanced sectoral agreement around environmental assessment. It is very, very, very helpful, perhaps, in providing high levels of environmental assessment for marine geoengineering activities and other geoengineering activities on land and air, but it's essentially limited to the European countries. So it's very much has very limited coverage outside Europe. So again, good rules, but constricted in operation. The third and final limitation I'll mention is that the rules that we're mentioning here so far have largely been developed for other purposes. So, for instance, when I was talking about the Law of the Sea Convention and its obligations in Article 192 about protecting and preserving the marine environment, these are rules that have been primarily developed in the early 1980s with marine pollution incidents in mind. It's that geoengineering wasn't on the radar back then. Climate change wasn't even on the radar back then. And so these rules tend to be very directed at a particular pollution problem and do not contain provisions in them that allow for what we term now to be a risk-risk trade-off. That is, assessing the risk of, say, the activity, polluting activity going ahead and continuing, balancing or assessing that risk against the risk of it not continuing, and say in the geoengineering case, climate change continuing unabated. So that most of the rules we're looking at here suffer from that problem in the sense that they narrowly assess the risks of a particular activity upon the marine environment, but don't necessarily have the capacity to look at the benefits of marine geoengineering and how that might actually provide a significant benefit to the marine environment that needs to be offset against the risks of harm. So with that, I'll finish and hand over to Kerryn.
Thanks, Jeff, and thanks, Wil. So I'll pick up where Jeff left off. Jeff's just talked about the large patchwork of rules that govern activities in the world's oceans that may be relevant to marine geoengineering activities. And I think within this patchwork, the London Protocol on ocean dumping deserves particular mention. Now, the London Protocol is part of an international regime that establishes rules for the dumping of waste at sea. And I'm just going to share my screen so you can see my slide just a second. Can you see that?
Yes.
Great. So it's part of a regime that governs the dumping of wastes at sea. And in 2013, the parties to the London Protocol negotiated an amendment that would enable the protocol to govern marine geoengineering activities. Now, this was the first attempt by states to create legally binding rules for marine geoengineering under international law. So it's a really exciting and progressive development. This amendment also was heavily informed by scientific consultation and expert consultation. And what it does is it establishes a framework that can be used to govern other marine geoengineering activities as they might be developed into the future. So it provides a really great model for governance that can accommodate the development of new technologies into the future. But it's important to recognise some of the limitations of the London Protocol when it comes to governing marine geoengineering activities. And the first limitation that we highlight in our report is that at the present time, the amendment only creates specific rules for ocean fertilisation. As I said, there is some scope for other marine geoengineering activities to be governed into the future. But something to be aware of is that the operative provisions of this amendment only apply to activities that involve the placement of matter into the ocean. So this may mean that the amendment has limited capacity or might not apply to activities that don't involve placement, the things like marine cloud brightening or ocean upwelling and downwelling. The second limitation of the amendment is that it doesn't consider directly that need to address climate change. It focuses on the need to protect and preserve the marine environment from the risks of marine geoengineering activities themselves, and this would extend as well to research activities. Now, this is in keeping with the overall mandate of the London Protocol and Convention. But what it means is that this amendment doesn't consider that bigger picture that Jeff mentioned of balancing the risks of geoengineering against the risks of climate change and the importance of furthering research in this context. The third limitation is related to that point that Jeff raised about consent and the need for states to consent to be bound by rules of international law. And at the moment, the amendment has had poor uptake amongst states and has limited capacity to bind only the parties to the protocol at the end of the day. At the moment, out of the 35, we need 35 parties out of 53 to accept the amendment and to have it enter into force, to have it become a binding part of international law. And in the past 6 or so years, only 5 states have given their consent to be bound, ratified the agreement. That's the United Kingdom, Finland, Netherlands, Norway, and Estonia. So given these limitations, we suggest that we can't rely on this amendment on its own to govern marine geoengineering activities into the near foreseeable future. We need to consider other alternatives to strengthen the capacity of international law to govern marine geoengineering. And this brings me to a new agreement for biodiversity beyond national jurisdiction. So as many of you have probably heard, there's a new UN agreement that's currently being negotiated for the conservation and sustainable use of marine biodiversity in the high sea. Now, the negotiation of this new agreement is well and truly underway. The most recent draft was released in January, and the next round of negotiations is set to start later this month in March 2020. And that's intended to be the final round of negotiations. Whether it is or not will yet to be seen. But the purpose of this new BBNJ agreement is to build on existing rules and principles under the law of the Sea Convention to protect biodiversity in high seas areas from existing and emerging activities. This includes things like deep sea mining and marine bioprospecting. So the thing to remember is that this new agreement is intended to be broadly applicable in scope. It's not a geoengineering specific agreement. There's still a lot of work to be done as well in finalising the agreement. The draft contains a lot of alternative provisions that will have implications for the agreement's capacity to respond to activities that affect high seas areas, including marine geoengineering. Since we released this report, a new draft has come out, and some of the draft articles in that report promise some pretty exciting developments. Most notably, it sets forth very detailed provisions for environmental impact assessment. This includes provisions under draft Article 25 to address cumulative impacts. This can be from multiple different activities or from the same activity over very large timescales. The draft articles also prescribe minimum content for environmental impact assessment reports, so what they actually have to do, what they should address and include. And there's also rules in there regarding public and stakeholder consultation. So in short, this draft contains some really progressive developments, and it has this ambition of developing rules that go well beyond the scope of existing treaty and customary international law rules, particularly concerning environmental impact assessment. So the negotiation of this new BBNJ agreement, we see it presents both an opportunity but also potential risks for marine geoengineering research and eventual deployment. I'll just go through those opportunities and risks now. So this new agreement could fill some of those gaps that Jeff highlighted in the existing patchwork of international law where high seas areas are concerned, particularly those really progressive and detailed provisions regarding environmental enforcement. Now, there's always a risk that any new BBNJ treaty will be slow to enter into force, or that key states may not consent to be bound by it. However, at the end of the day, this new agreement may still provide more detailed rules capable of being operationalised for marine geoengineering. And indeed, if we look at some of the preparatory committee meeting records, you'll see that some states and NGOs actually recognise the potential for this new agreement to govern marine geoengineering activities. In 2016, the African Union suggested that maybe marine geoengineering activities should be specifically listed so that they automatically trigger the environmental impact process. Marine geoengineering isn't mentioned in the current draft at all, but if you look at draft Article 29, it certainly opens up this possibility of specifically listing certain activities to automatically trigger an impact assessment. The risk with BBNJ is that these are going to be generic rules at the end of the day, and they may again not be fit for purpose for marine geoengineering governance. Remember, the purpose behind this new agreement is to protect biodiversity in the high seas, not to govern emerging technologies to address climate change. So the rules that are developed, you may find them to be overly prohibitive or restrictive at the end of the day. And this agreement, again, is unlikely to contain those mechanisms that Jeff talked about to balance the risks of marine geoengineering, especially research activities, against the risks of climate change. And, they could stifle responsible marine geoengineering research, which is crucial in this bigger picture. So we argue in our report that it's essential that marine geoengineering experts engage directly with this BBNJ negotiation process. So there's still time, there's still negotiations to take place, and that international lawyers and policymakers specifically consider the implications any new agreement may have for research and any eventual deployment of marine geoengineering. This is important to ensure that whatever international laws come out of this negotiation are fit for purpose. They help to fill some of those key gaps in that existing international law patchwork, but also that they're not so prohibitive as to stifle legitimate scientific research. So with that, I will hand back over to Simon and Wil to manage comment. Thank you.
Hi everybody, my name is Simon Mickelson. I'm co-director with Wil Burns of the Institute for Carbon Removal Law and Policy at American University in DC. We're going to move to question and answer now. Wil, is there anything you'd like to say as we transition into that next section? I'll take that as a no. So what we'll invite folks to do is just to use the chat box for any questions that you might have. As we wait for questions to come in via the chat box, Kerryn, you left us with a provocation. You said that much of the current legal framework, if you like, and much of what's developing seems to be, by some measures, overly prohibitive. And so I wonder if you can give us some thoughts and guidance about how responsible innovation could be generated through legal mechanisms. What are you actually looking for or calling for here?
Thanks, Simon. Are you talking about international law as a whole there, or the rules coming out of the BBNJ negotiation?
If you could cover both, I think that would be helpful.
Okay, so in terms of international law as a whole, I actually wouldn't say that that's overly prohibitive as it currently stands. I think it's quite general. And there's a lot of room for, different interpretations, and, those interpretations themselves could be potentially prohibitive or permissive of marine geoengineering activities. A really good example here would be looking at customary international law and the obligation that Jeff mentioned to prevent significant transboundary harm. The trigger for that rule to come into operation is that threshold level of significant harm, but we don't have a clear definition of that in international law. It's open to very broad interpretation, particularly from states themselves. If we look at the BBNJ draft, as I said before, there's a lot of options in that draft that could go either way, but a good example is looking at the scope of how that, where that, and what kind of activities that, that agreement and the environmental impact assessment processes will apply to. And there's two options at the moment. One that's quite progressive is that it could be triggered by any activity, regardless of where it is, that might impact on high seas areas. So that could include marine geoengineering activities taking place in a state territorial or coastal waters or an EEZ. But the more likely option at the end of the day that I think we would see states agreeing to is that it will only apply to activities in high seas areas. So that's quite a difference, as you'd see from where those rules might apply, what they might see.
Thanks, Kerryn. Wil, you should be unmuted now, and Jeff.
Yeah, look, I think it's a good question, Simon, about what would we see in an ideal world in terms of the international law system and how it responds to marine geo. I think I can sum it up three ways. In terms of the BBNJ process, I think BBNJ not get in the way. Okay, so make sure that we don't have something going on, in the Law of the Sea Convention that might actually stifle research around marine geoengineering activity. So I think that's really important. So whatever happens out of the BBNJ process, it doesn't get in the way of responsible research. So it doesn't have overly prescriptive or restrictive environmental assessment requirements or other measures that might actually stifle good work. In terms of London Protocol, we'd love to see more ratifications, expanded coverage, and also probably an explicit ability within that agreement to make those risk-risk trade-offs. So I know there's different views about the extent to which the protocol can allow that, but given its mandate, its overall mandate is about marine pollution, its aims and objects about marine pollution, there is some doubt about the extent to which it can actually achieve or perform those risk-risk trade-offs between geoengineering activity and not acting and allowing climate changes to go on unabated, right? So to make that more explicit within the London Protocol, London Convention would be great. The other thing is UNFCCC. If the UNFCCC could pick up and develop rules around carbon accounting and whatnot for blue carbon, and even take an interest in the actual regulation of marine geoengineering, that would be great. But of course, we know the problems of the UNFCCC at the moment. The consensus decision-making rule around nearly 200 countries is probably going to make that unlikely.
So we have, in fact, a couple of questions, Jeff and Wil and Kerryn, about management across these different regimes, right? So you mentioned the UNFCCC, Jeff, and how it might be hard to partner between UNFCCC and other parts of the international legal apparatus. Some folks are saying that that's the only way to actually manage something like geoengineering, because we're never going to have a standalone agreement, probably on all aspects of marine geoengineering or other forms of geoengineering. So how does one manage effectively across the patchwork? Or does it make more sense to keep things separate?
Look, I think the only way to manage across the patchwork is through really careful integrative work between the various international organisations involved in those various sectoral agreements. That's difficult, and in the past there's not a great record of that type of deep integration. That's the only way we can really see it working as it currently stands. The other alternative is to not seek an overarching approach for the UNFCCC, but as I said, try and build up from below with what's the great work that's been done on the London Protocol. As I said, look for greater ratification, greater coverage, more explicit sort of provisions and approaches to that risk-risk trade-off, so to build up from below through the London Convention and the BBNJ process that Kerryn spoke about.
I guess one thing I'd add is there's at least some precedent for cooperation between regimes in the context of geoengineering and marine geoengineering more specifically to date, and that's between the Convention on Biological Diversity and the London Protocol. There's at least been more than a nod between them of acknowledging the need for risk assessment, the contours of risk assessment, and the CBD to some degree allowing the London Protocol to take the lead in that context, but also contributing itself in the specific context of the potential impacts of marine geoengineering on marine biodiversity. And that might be a salutary model where some of the individual regimes with specific remits focus on that work while taking up or nodding to the work of other regimes in other components of this.
Okay, Kerryn, we've got a couple of questions there specifically on the London Protocol and its remit and its ambit. I wonder if you can see those questions and whether you might have response to them.
So I've got one here about the capacity of the London Protocol to govern activities like artificial upwelling. And look, I agree that there is the potential, and I hope this came through in our presentation, that there is the potential for the London Protocol in the future to govern new or other activities aside from ocean fertilization. But the problematic provision here is Article 6 bis, which is the operative provision I mentioned. It prohibits, and I quote, the placement of matter into the sea from vessels, aircraft, platforms, or other man-made structures at sea marine geoengineering activities that are specifically listed at the moment. That's only ocean fertilization. But the wording of that provision, the placement of matter, will limit the operation of these rules to activities that actually involve placement. If they don't involve placement of matter directly into the ocean, then there's a good chance that they may not be able to govern those activities. And this is something that a number of international lawyers have pointed out as the significant limitation in the potential scope of those amendments.
Right. I'm also seeing some concern that letting biodiversity bodies govern marine geoengineering might be counterproductive. So, Kerryn, since you covered this biodiversity beyond national jurisdiction, BBNJ notion, what's your response to that?
I don't think it's so much a question of letting, but a question that they are developing under the new BBNJ agreement negotiations, general rules that will apply broadly to any activity that meets their, geographical coverage, so activities perhaps in high seas areas that meet certain threshold triggers, and that those triggers are going to be based on the impacts or risk to biodiversity. So it's not that new negotiations for a new agreement aren't aiming, as I said, say to govern marine geoengineering. Might just be that it can create rules that fit by those activities at the end of the day, and that's why it is so important that international lawyers and policymakers involved in those negotiations consider what effect they may have, particularly for marine geoengineering research, and that those of us with expertise in geoengineering and marine geoengineering governance engage with that process and don't ignore it as just another biodiversity convention. It's something that could have a significant effect in this regard.
Yeah, Simon, I think that's the question from Lily in the comments there. I think that's a good one because there has been that history, the late noughties sort of history of those resolutions were put through the Biodiversity Convention, which I think in hindsight many would see as being an ultra precautionary approach that was taken at the time. I know there's been some work done around the NGO involvement in those resolutions that went through the Biodiversity Convention. But so I think it's important to not allow one particular part of the patchwork to develop in a way that will be overly restrictive on particularly research and field testing in marine geoengineering, because we know that the assumptions that are being built into the integrated assessment models, 1.5 to 2 degrees, have got huge carbon drawdown expectations for 10, 20 years down the track. So we need to make sure that we're not closing, not being overly hyper precautionary in terms of our approach. And as I said, certainly that past in the biodiversity you mentioned might be viewed that way, in hindsight.
And Wil, since you're off screen, just an opportunity to say anything on that point if you'd like to.
No, I think that was pretty good coverage.
Great. So another question that's just kind of floating around in the ether is the use of this label of geoengineering to encompass a whole bunch of different things, right? So on the policy or politics side, there's been a lot of recent moves to say that carbon removal should be treated as part of the climate change mitigation agenda. And it should be seen carbon removal, sucking carbon from the atmosphere and putting it into storage, is just something that needs to be done now and shouldn't be treated in the same way as more speculative, reflecting sunlight back into space stuff. So can law account for that type of political move, or are we kind of stuck on a track now where geoengineering is the dominant way to understand these technologies in relation to each other?
Right. Well, I'd say something about that. I think it's unfortunate that we have the label of geoengineering in general, but nonetheless, it is how a lot of people understand it in the community. I think it's beneficial to disaggregate each technology and assess each technology in terms of its own potential risks and benefits. But one of the things I'd say is, while I do agree that carbon dioxide removal approaches would fall under the rubric of mitigation as defined under the Framework Convention, and certainly as in the spirit of Paris, even though the term mitigation is not defined in Paris, I wouldn't draw the same distinction that some of these others are more speculative, and CDR is simply a variant of other forms of mitigation. I think, as the study points out, when we look at marine geoengineering carbon dioxide removal approaches, there are plenty of potential risks associated with large-scale ocean iron fertilization in terms of ocean ecosystems, or ocean alkalinity enhancing, or downwelling or upwelling proposals. And so whatever way we label this, it's important that they be subject to stringent assessment and not merely characterized as another form of mitigation that we automatically and blithely adopt as acceptable.
Thanks. Jeff or Kerryn, anything on that point?
I think Will's right. We're kind of stuck with the language of geoengineering in the sense that it's been built in, the London Protocol and even the UNEA resolution that was tried last year. So I know there are some good practical and political reasons for trying to separate out CDR and SRM, and I applaud those efforts. But certainly from the legal perspective, words matter. When we have words that have been set down on paper, and so it's a little hard to sort of backtrack from that quickly. Maybe I'll be done in time. We maybe want to separate out new agreements and resolutions which don't use the geo word, but I think we're going to be stuck with it for the time being, at least in the legal space.
How does what you're thinking about apply to potential rogue actors, not just states, but also potentially corporations or even individuals who might engage in marine geoengineering?
Kerryn, could you talk about state responsibility there? That might be a good entree.
Thank you. So, generally speaking, international law only binds state actors, not individual private or corporate actors. But that doesn't mean that the rules developed won't affect the end of the day, and that's because states usually have an obligation to, enact and enforce the laws, the international laws that they agree at the end of the day. And so they may find themselves responsible, states may be responsible for the actions of private actors or individual actors, depending on whether those activities can be attributed to something that's been sanctioned or by a state. So, there is the capacity there for international law to affect the actions of states. And if we look at a great example here is the London Protocol itself, which governs dumping activities. If you look at most parties to that, they will have domestic laws that then implement those rules and those obligations for individual actors at a domestic level. So there is that kind of flow-on effect where international rules can therefore, through a few steps, affect or govern the behaviour of individuals as opposed to.
Right, thank you. And then a different question from the same person in the chat box here. Setting aside any existing international law agreements, is there anything else out there that could guide us in terms of frameworks or policy as we think about the future of geoengineering law? So I guess part of the question here is what analogues beyond geoengineering exist to help us understand what it would take to govern geoengineering effectively?
Yes, look, I mean, there's been some, really good work done over the last sort of 5 to 10 years by a lot of folks in the science and technology studies area, particularly, looking at the uptake of other novel and highly risky technologies in the past and what lessons can be drawn from those experiences. So, I mean, that's sort of non-legal literature, but it's also very, very helpful, I think, in informing the way the law might develop. The key lessons that come out of that literature are those ideas around responsible innovation. I think that one of the early questions referred to, that is the importance of making sure that public support, public engagement is happening at a very early level of technological development and testing, so as to not lose the public at the very start of a technological pathway. The other thing is to keep open governance at an early stage, so that it's flexible, so that it has the reflexivity and ability to be able to adapt as new ideas, new scientific knowledge, new technology develops, because with novel and risky technologies, it's very hard to see into the future as to which way they're going to go in terms of their social and environmental and economic impacts. So that idea of early public engagement and also reflexivity and flexibility in governance structures is, I guess, the two big lessons that come out of that literature, which I think as lawyers we really can engage and use well.
Good, thank you, Jeff. So we're approaching the end of our time. Let me just, in the chat box, give a link to the report. The report title again, Jeff or Kerryn? Governance of Marine Geoengineering, do I have that right? You wrote it
yes.
A couple of months ago, so you've already forgotten the title.
Yes, Governance of Marine Geoengineering for the Centre for International Governance Innovation in Canada, and of course we're all three of us are very thankful for the funding and support we received from CIGI for producing the report, and also very thankful to Simon, yourself, and Wil for organising this great webinar.
A real treat, Jeff, and Kerryn, good to see you. Hey, Wil, any final words as we wrap up?
I guess I'd say that I think it's really important, given some of the issues that we've talked about, for these international treaty regimes to look at in earnest about how research and public engagement and risk assessment can be effectively developed, because it's going to be important, I think, to facilitate the research that critically needs to be done, as well as to try to ensure that the diverse interests that may be associated with potential deployment of these technologies, whether it's in the global commons or in other countries' jurisdictions, are respected. And it's better to be engaged in that discussion at this point than trying to react after we start putting some of these things potentially in place.
Thanks, Wil. That gives you the last word, Kerryn, if you would like it.
I would agree with what Wil said, that it's important to be on the front foot with responding at the end of the day, and just to thank everybody for taking the time to tune in. And if you've got questions, you can find our contact details in the report, and feel free to send us an email. Thank you.
Thank you, Kerryn, and thank you, Jeff, for getting up so early, Australia time. This webinar, along with others in our series, will be archived at the Institute for Carbon Removal Law and Policy website. The website address is carbonremoval.info. You can see it linked there in the box. Thanks again, Jeff McGee, Kerryn Brent, and my co-director and friend Wil Burns for organising this webinar. See you all again soon.
Okay, thanks, Simon.
Thank you. Cheers.